Good evening. My name is Lewis Powell. It's my pleasure to be with you once before on behalf of the Cook County Bar Association, the world's oldest, I like saying it, the world's oldest African American Bar Association, actually incorporated in 1914 here in the city of Chicago. And our guest today is Mika Thompson, who's actually the producer of the show and does a whole lot of things. But from time to time, we play various roles. Today's topic is a very important topic, is estate planning.
Right.
And Mika, this is a very important topic. A lot of people like to talk about it, but it's still, very important,
Yes.
because you just want things to be in order. Nobody likes things to be a hot mess after you go home, to be with the Lord. You want things to be in order.
Right.
We're going to start out with some basic questions. Mika, what is an estate plan?
An estate plan is basically a group of documents that incorporates a proposal or an agenda that you and your attorney have come to an agreement as to how you're going to distribute your assets. So the plan entails a lot of documents pertaining to assets, pertaining to directives, pertaining to like your real estate, your health care. The estate plan can involve retirement plans. It can also involve something as simple as a promise to be present, designating someone to be present at the time of a family member's graduation from college. I mean, you can be that specific in it. And we'll talk more about those different things, but it really is encompassing the overall concept of how your assets and your responsibilities in this life will be directed by people who outlive you.
Because, Mika, what you want is you really, if you leave something for somebody, you want them to enjoy it.
You want them to enjoy it.
And you want things to be in order.
And you also want them to be responsible so that the estate plan can take responsibility or identify a person who will take care of your children. So, that may not always be enjoyable,
right.
but
that is true.
But it's definitely necessary that you designate someone to do that. So,
Attorney Thompson, what's involved in preparation of a estate plan?
So that's one of the really important things that I want to stress, that people spend some time and think about what it is they want to achieve after they pass on. What is they want to achieve if they get sick? What do they want to make sure is taken care of if they become incapacitated? So because you can't really put together a good estate plan unless the person who is going to be the subject of the estate plan really thinks about what it is they want to have done. So it's not simply, most times when we think about an estate plan, it's simply the assets. It's not simply the assets. An estate plan, as I said before, can incorporate who you designate to take care of your children, who you designate to take care of you in the event that you get sick or you're unable to act on your own interest. So you really need to think about what it is you want to do. Then the next thing you want to think about before you engage an attorney is to think about who you want to be the person to take care of these different objectives, responsibilities, or enjoyment. Who do you want to receive the benefits of your assets? Who do you want to be responsible? And then with all estate plans, there's got to be somebody that's designated to do what you are not able to do for the benefit of those who you've designated to receive any of those assets. Who should that be?
Who is that person called? Is it a title?
It's yes. So for a will, it's an executor. For the trust, it's you have the settlor and the trustee. So the trustee is the person that you will designate if you have a trust. So these are the individuals that will carry out the responsibilities and that are designated in your estate plan.
Okay. When you go see counsel in terms of your estate plan, what type of information should you bring?
You should bring your information about your assets. So that would include any real estate property, cash money, checking accounts, retirement plans, as well as stocks, bonds, Also, you should include information with regards to your personal property, like paintings that have some value. Now, that may not simply be value on the marketplace. There may be some paintings or photographs that family members value. So those would also need to be included and described. You would also need to, if there's any type of furs or different clothing that you think a family member would want, or a friend that would want. For example, I'm a member of Sigma Gamma Rho sorority. There may be some things that I would leave to my sorority members. And you are a member of Alpha Phi Alpha.
Get it right now, Alpha Phi Alpha.
And so, exactly. So that may be something. And these are the type of things that we really don't think about. So you want to put all of those things in the estate plan as you go down that list of things that you want. The other things are the responsibilities. As I said, if you have children, you'd want to designate someone to take responsibility of that. There's plenty of people that designate people to take care of their animals if they pass away. So that would be something that you'd also want to involve in the estate plan. If there's certain things that you want to have done. I remember in the movie The Bucket List, there was a designation by one of the main characters in the story. I'm not going to tell the whole story, but he designated someone after he passed on to handle his his ashes. So, and where to distribute those after he passed on. That's a common thing that people will do, is to say that I want my ashes, distributed in the grave site near my family member, or over an ocean, or so whatever it is that you want to have done, that would be the subject of the things. So it's not simply just the assets in personal property. It's cash money. It's different responsibilities. Your what happens at a funeral. You can describe all those different things that you want to have done when you pass away, and put that in your estate plan. So
Before we forget, we have to make sure that you know who to call.
Okay.
And that number is 312-738-1060. 312-738-1060. That is the direct line. It's no fun. Me and Mika and myself, we could talk here all day. But the purpose of the Cook County Bar is really on a serious matter, to really give information to the community. And we really, to the best of our ability, to the extent that we have, we want to share the information that our guests have with our audience. So please, give us a call, 312-738-1060. Mika, how about your accountant?
Your accountant would also be a party to. So if you are doing a will or a trust, you would want to engage an attorney. You would want to engage your accountant. You would want to engage maybe a funeral director to give you the different prices and the options with regards to any type of funeral arrangements. And you also would want to engage a tax professional to provide you, okay, if I have these assets, if I give them to my family member, who pays the taxes?
Right, ladies and gentlemen, that's a critical point. Because again, if you have something to leave, you want people to enjoy it. You don't want to put them in a position, if they get something per the will or trust, whatever, that they're getting hit with a large amount of taxes. You want to see, to the best of your ability, what you can do to lessen that burden. You need to get with your accountant, your tax person, because there are a lot of little nuances that you can do while you are living to really start taking away from your estate to lessen the value.
Exactly.
Now, is there a benchmark? When I say a benchmark, is there a benchmark in terms of the word probate, in terms of when an estate has to be probate? A lot of times we hear the word probate. Could you give us a definition of probate?
Okay,
and what triggers it?
So once you, if the person has done a will, that has to be probated. And what that means is a will has to be placed, filed with the court, and then the court will enforce the terms of the will. Now you have 2 years from the time that the person dies for any type of claims to be filed with the court pertaining to any assets under the will. There's 30 days from the date that the person passes away with regards to the probating of the will, but I've definitely seen where the court is not such a stickler for the 30-day rule, especially when people are grieving. You know, a lot of people aren't running the court within 30 days of the person passing away. But they, so those are the benchmarks. A person that has passed on, the probate estate can be open, and the court will file those documents with the probate, in the probate division of the courts in any state, including
Is there a
Illinois.
dollar amount?
There is a fee. There's definitely
In
a
terms
fee.
of the value of the estate that you have to do going to probate?
No, there's not a like a sliding scale or anything. It's a flat fee for filing opening a estate with the probate court.
What if you don't have a will?
Well, if you don't have a will, then the laws of intestacy take over, assuming that you don't have a trust. Now, the difference between a will and a trust is that a trust is considered a non-probate asset. That means that it's not, in order to enforce the terms of the trust, you don't have to go to probate court and have those terms enforced. The probate court does not address non-probate assets. Anything contained in a trust automatically transfers by the terms of that trust agreement.
For example, how about a piece of property? Can you put a piece of property in the trust?
Yes, you can. You can put a piece of property in the trust. Another non-probate
But
asset.
question,
Okay.
if you put the piece of property in the trust, Mika, what happens upon the person's death? Is there any room for argument?
Oh, yes. So, and that's another. I do need to qualify that. If there's no argument, then the trust can remain a non-probate asset. However, if there is some disagreement with the beneficiaries to the extent that they feel like the trust was not properly executed or that there is some fraud involved, a court may entertain a cause of action in probate court to address the terms of that trust. If the trust designates a beneficiary that is not identifiable, for example, if the beneficiary is listed as Mickey Mouse, then of course the court may be called into that trust may be the subject of a probate action because there's no such person as Mickey Mouse. Or if it names somebody that is in existence but the name of the person is spelled wrong, or it's a nickname, it's not there's not a name that shows up on their driver's license or state ID. The trustee that is responsible for administering that trust may file an action in probate court to ensure that there's no lawsuit against him or her if they distribute those assets pursuant to the terms of the trust to somebody that they really cannot verify their identity. As an attorney, that would be my advice to that trustee to seek
Mika, how about this? Let's talk about a simple land trust. A simple land trust meaning a piece of property is put, for example, not to plug in, but we're just going to say Chicago title.
Okay.
You put a piece of property in Chicago title. Explain to our audience how simple that is in terms of doing it and what happens upon the death of the person who owned the property.
Now, the title companies are reputable. If you get a title company that's reputable, and I mean a company that has been in existence for a long time, they will provide you with, and these tend to be form documents that clearly identify all the different provisions of a trust, and they charge a fee. It's a very nominal fee, and it's a yearly fee to hold that property in trust. They give the trust a name, and they specify the terms of the trust in terms of whether you want the property to pass directly to the beneficiary. They've got the legal terminology that can be used to make sure that the property passes for that person's lifetime, or and then after then is passed to another person. So it really gives you that type of flexibility that you would like, because it's not just one form that can be used. It's a multiple different languages that can be implemented in the trust to achieve the goals that you want, that that all trusts should be able to do. And it's much more of a simplistic process. And again, but you really need to have your goal, if you put it in a land trust, is that it transfer within a reasonable amount of time and for just set purposes. They're going to either live in it, they're going to sell it, or they're going to live in it for their lifetime and pass it on to somebody else. You see, it can't be, well, this person is going to go to use it and go to college, and then the next person to take the proceeds. And, it can't be a really kind of complicated thing. It really needs to be more of a simplistic objective with the land trust.
Explain to our audience, what we just talked about is just a simple land trust, because a land trust, ladies and gentlemen, is very simple. Something happens to the person who owns the property, usually without any arguments, not too much wiggle room for argument. You just bring the death certificate to, for example, Chicago Title, and the Chicago Title will convey the property in accordance to what's stated in the trust. Mika, explain to our audience the difference between like a trust that's set up by a private attorney, where you have property, where you have money, where you're doing different type of things.
Well, that's the difference. You're doing different type of things. You're not just transferring one piece of property or multiple properties. You can do multiple properties with a land trust. With Chicago Title, they will prepare a trust for that purpose. But it usually is, when you go to an attorney, you want, again, certain responsibilities, like, again, taking care of your children after you pass away. You want to make sure that retirement funds are used for you and your lifetime. You want to make sure that that in addition to the land, that personal property is distributed to people or beneficiaries. Again, you can make certain promises pertaining to making sure that a certain members of the family are there at a family member's graduation, and you can make sure that your health care, if something happens to you, or you're just sick or incapacitated, you haven't passed on yet, that you designated someone to make decisions for you while you're in the hospital. Your organs, you can just designate that your organs are donated. Right now, we're in an electronic age. In your Facebook account, your electronic medium, you can designate what happens to that. So all of those different things are not going to be achieved using a land trust.
Well, Mika, how about this? Because most parents know their children. Now, what if you got child number A, child B? Child A has been pretty responsible, but you want to take care of child B as well. Would it be possible to set something up where the child A basically makes distributions to child B upon their needs, in terms of going to college, so forth and so on? Is that possible?
Yes, it is. So long as you know that the child that you designate to make those responsibilities happen for the benefit of the other child is going to actually be able to do that, and without there being any further animosity between the children. Because what happens is you're basically allowing one child to have control over money for another child. And so long as they are capable of doing that without damaging their relationship, yeah, that's not a problem at all. And there are plenty of families where, the parents are able to say, okay, Sally, you make sure that John gets this money, for their school, or a training program, or a car, whatever it is that you would like. The best way to assess whether or not a child is going to do that is to look at what they're doing now. If they're the type of child that are assisting their other their other siblings in making financial responsibilities without any grumblings or so forth, then that's the child to do it. But if the child is not doing it now, there's no reason to believe that they're going to do it after you pass on. Okay, so this is something that particular child is taking on their own effort to make sure that their other siblings are financially taken care of, then you can rest assured that they'll do it after you pass on. But if they're not doing it before, they're not going to do it after you pass on.
Ladies and gentlemen, this is the Cook County Bar Association, and we are very serious about the people's work, as we say in the business. The following is our information: 312-630-1157, extension 21 for the Law Referral Program. Ladies and gentlemen, we are about as hard as we can to give information to the community that you can use.
And there's one more point I'd like to make with regards to what you're talking about. When you have siblings that are under some sort of disability due to drugs or alcohol or gambling or those type of things, you really need to assess whether or not it is in that child's best interest to receive cash money. Usually those individuals may be surrounding themselves with people of not the best character, and if they are receive a lot of money, that can put them in a very dangerous situation. Furthermore, it may encourage them to further indulge in whatever type of addiction that they're currently being resolved in. It may be in your the child's best interest for you to consider taking that money and designating that money go to some sort of treatment program, housing. I mean, right now you can even pay for groceries for a year for, people, something where they can pay it off at one time and it will go towards something specific that will help them. I strongly discourage people from giving cash money to any child or family member or friend who is suffering from some sort of addiction.
Good point. Mika, we just got a couple of minutes. Let's see, can we hit a couple of quick topics
Okay.
so our folks can, get as much information as possible. What happens if the will designates something, and of value and there's not enough money in the estate to take care of that? What
Okay.
happens?
So you're talking about in the will. Okay, so what that is called is you're calling an abatement. And so first off, you really should, any estate plan that you prepare, you really need to make sure that you can maintain the accounts with the funds that you want to distribute until you pass on. If for whatever reason you're unable to do so, contact your attorney and have the will changed to reflect what is actually in the account. But in the event that you pass on before you can do that, the courts will be called in to address that fact, and they will do what is called an abatement, and they will divide the remaining assets to the best that they can in accordance with the statute among the remaining beneficiaries that are there, assuming that there is not some sort of asset that specifically can't be, like, if it's like a college degree or something like that, or something that really would be, the value of that would be diminished completely by abating it. So it is a discretionary thing that the courts would the judge would make a decision, and the attorneys involved who are representing the beneficiaries would make their argument according to the law and the case law that is current at that time. But again, just as a general rule, that it would be an abatement, and then the remaining assets would be reduced in accordance with the statute and the case law that is existing at that time.
Mika, we have 2 minutes. Quickly, if you can. What are the responsibility of the executor or the administrator in terms of working with the attorney doing probate?
Oh, okay. So there's a duty for the administrator to provide, or an accounting and so forth to the attorney pertaining to the assets that are designated in the will. They have a duty of loyalty to all the beneficiaries. If there's ever any type of conflict of interest, the attorney may ask for them to resign and another person step up for that. They also have a duty to just be honest and act with integrity with regards to the distribution of those assets.
Very good. Mika, it's been a pleasure. As always, you always bring information that we could use. We'll be back again the same time, same station next week. Again, this is the Cook County Bar Association. God bless you.